court also has inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
And there you have it. And this morning, we want to welcome a very special guest onto the program. You saw her in action in this trial, and she resigned right before that hearing started. I want to welcome in Special Prosecutor Erlinda Johnson. Erlinda, good morning to you. Thank you for being with us. Good morning. Could we start, please, with why you resigned? Would you share with us the reasons behind it, please?
Absolutely. As you, I think, all heard on Thursday evening or Thursday afternoon, Mr. Spiro, Mr. Baldwin's lead defense counsel, cross-examined the crime scene technician about this ammunition that had not been turned over or made available to the defense. And that's the first time I learned of the existence of this ammunition that had been tagged in under a separate case number. Then on Friday morning, when we show up to court and the court ordered that the ammunition be brought into the courtroom, if you recall, the judge dramatically opened this envelope and these bullets started being taken out of the envelope and categorized by the type of ammunition, according to the report, that was tagged in under or submitted under a separate case number. 3 of the rounds appeared similar to the rounds that were found on the set of Rust. And so at that point, in my mind, this hasn't been turned over. This hasn't been made available to the defense. The state hasn't done anything with this. And I believe that at that point, the right thing to do would have been to dismiss this case.
Tell us what you did once you learned about this in the testimony when many Americans learned about it. What did you do?
I inquired. First of all, I asked, who is Troy Teskey? I was asking my co-counsel, I was asking the detective, who is this individual? And when we recessed, it was explained to me, well, these rounds were not similar to the ones found on set, and they were different. And the question was, why wasn't it made available to the defense? And that's a question I kept asking. And the belief was these were irrelevant. These were irrelevant because they had nothing to do. They didn't look like the ones on set. And I'm not sure my co-counsel had even looked at these physically. She looked at some photographs. And then on Friday morning, when we arrived in court and actually looked at the evidence, and looked at the rounds, 3 of them, as I said, appeared similar to the ones that had been found on set.
Erlinda, at that point, did you tell Carrie Morrissey that we should withdraw the charges?
I did. As if you recall, the judge excused the jury for the day. We requested breaks. We all conferred. My reaction was, I think we should walk in there and move to dismiss, because this is a violation. And keep in mind, I mean, this was, I believed in this case. I believe that there was reckless conduct on set. A woman lost her life, a woman was killed. But at the same time, I took my job as a prosecutor very seriously, and evidence has to be turned over. We don't get to dictate what the defense is going to be. If it's material, potentially material, if it could assist in raising potentially reasonable doubt or impeachment of witnesses, it has to be turned over.
Erlinda, you're exactly right. So when you told her what should be done, what was Carrie Morrissey's response then?
She wanted to think about it, and then I believe in the end, what she wanted was to just put all the facts in front of the court, in front of the public, how these rounds came to be, how it all transpired, how the state did not believe that this was relevant. And it is possible it may not have been relevant. And the jury could have just disregarded that. But it needed to be provided, and it needed to be litigated in court, whether that was going to be introduced or used. The point is, it wasn't provided. That was my issue.
And you were right to have that issue
think
ethically. Oh, please go ahead. I didn't mean to interrupt you.
No. Sorry.
That's okay.
No, and in the end, when we came back after lunch, I sat there and I thought, this isn't right. This just is not right. This should be dismissed on the state's motion, and it's not. And so that's when I approached and asked to withdraw.
You upheld your ethical duties as a special prosecutor, and the judge obviously granted your request to withdraw, and we all learned about it, as you know, when Carrie Morrissey made the decision to testify, and Mr. Spiro crossed her on it. And when she was asked about the reason why you withdrew, she said, and I'm paraphrasing here, I don't know her exact words, but it was something to the effect of, well, it's my understanding that Ms. Johnson didn't agree with having this hearing here today. Now hearing what you're saying, that doesn't seem like it was an accurate representation of why you withdrew.
That's correct. In fact, if I remember correctly, I wasn't watching. I was told afterwards that she said the reason I withdrew is because I didn't agree to a public hearing on the motion, which was not accurate. I didn't agree with going forward with the hearing. My belief, my thinking was the state should do the right thing and go in there and file a motion to dismiss. It is unfortunate. It was unfortunate for Helena Hutchinson's family, but the defendant has rights, and the defendant's entitled to due process and to have all the evidence disclosed.
You're spot on. Upholding your duty and the oath that you take when you serve as a prosecutor. And you're exactly right. It wasn't for her to decide. It should have been turned over. And as you said, then it's for the jury to decide and defense counsel to choose to do with it what they will. Speaking of the defense case, you said earlier you believe in the case, in the prosecution. Curious what you thought of the court's decision to dismiss with prejudice, because we know the judge had the option to just declare a mistrial, postpone the case, say maybe 90 days, allow time for testing, allow time to regroup, set a status conference, and then push it out for trial at another date. Did you agree that dismissal with prejudice was the right remedy?
You know, at that point, I think that obviously, as we all know, jeopardy had attached. She could have declared a mistrial with manifest necessity, but unfortunately, there had been previous issues, and this one was in the middle of a trial. I think for the judge, that was just too much.
Sure. Speaking of too much, you know, there was a strong reaction from many trial watchers watching Carrie Morrissey. That was certainly something we don't see every day, where a prosecutor calls themselves and gives a narrative and then is cross-examined. What did you think of her decision to do that?
I thought that was ill-advised. It's very unusual. I've never seen, in my 28 years of practice, I've never seen a prosecutor take the stand.
Right. Erlinda, tell me, in terms of what should happen with Hannah Gutierrez, do you believe she should get a new trial now based on this non-disclosure of the evidence?
You know, that one's a little bit different. As I think you know, I was not involved in the Hannah Gutierrez trial at all. My understanding, which I learned on Thursday evening, Friday morning, is that Mr. Teskey was a defense witness for Hannah Gutierrez, and Ms. Gutierrez's counsel asked that those rounds be brought to court by Mr. Teskey, and then counsel for Ms. Gutierrez said he was not going to call Mr. Teskey and sent him away. And that's when Mr. Teskey apparently went to the sheriff's department, and surrendered those rounds. But I understand that there are other reasons that counsel for Ms. Gutierrez is moving to set her conviction aside. There was a disclosure of a third expert, firearms expert report that was not made available to the defense in that case. That is an issue that I believe has already been raised or will be raised. As far as the rounds, it really depends on because the defense in Gutierrez was aware. That's the difference between the Baldwin case and the Gutierrez case. In Baldwin, the defense was not given those, or given the report, given the opportunity to inspect those rounds. In Gutierrez, her counsel was aware of those rounds. In fact, it was his witness who brought them to court. My understanding was that he showed them to counsel, and then he was sent away. The witness was sent away. So that's a little bit, I think that she is in a little bit of a different posture as it relates to that evidence. There may be other evidence that may come into play.
Serve as a basis for that. Right. I know that Attorney Jason Bowles does have a few other things. He'll be on with us tomorrow morning, so we'll certainly ask him. Want to say a big thank you to you. Thank you, Erlinda Johnson, for being so transparent. And might I just say, you wouldn't know this because you were busy in the courtroom on Friday, but prior to all of this occurring and the big hearing, we had done a segment on you because we were so impressed with your advocacy and the lawyering that you displayed in the courtroom. I know you've got many years experience as a prosecutor and as a criminal defense attorney now, and it showed. And so I think what we've really learned is what a tremendous lawyer you are, and also what an ethical one you are as well. So thank you for your time. Would love to speak again with you sometime.
Thank you.